Okay, our final case is Morrow versus Lytle.
May it please the Court, I'd like to reserve 2 minutes for rebuttal, if I may. I'm Ken Norrie, representing the appellant, defendant Russell Engineering, Inc. in this case, and also arguing on behalf of defendants KCCS, Inc. and Owen Ayers and Associates. This is an appeal, of course, from a non-final order, an order denying a transfer of venue on convenience basis under Section 47-122 Florida statutes. Very briefly, the nature of the action: collisions on I-75 in Alachua County, resulting in 2 fatalities. The accidents occurred on the approach to a construction work zone on the FDOT bridge project. Sued in addition to another driver and owner involved were what I call roadway defendants: the designer, the contractor building the road, and those overseeing construction. So it's a construction case to that extent. First action was brought by the driver, the estate of the driver, in Duval County. 8 months later, a second action was brought also in Duval County by the passenger, both whom were deceased. I don't think there was any argument on this, but that in both cases, all defendants timely sought a transfer of venue through their responsive pleadings or through motions or both. Both in the first case, the Lytle case, the second case, the Alexander case. The issues here today are, 1, did the trial court abuse its discretion in not transferring to Alachua County under the circumstances of this case? That's obviously our burden as defendants to show that on an abuse of discretion standard. And the second issue is one raised by the plaintiffs by way of avoidance, and that is, even if so, the defendants waived their right to transfer venue by their conduct after they initially timely raised the issue, and specifically by failure to appeal an early venue ruling. First, on the abuse of discretion point. I classified venue cases of this type into 2 categories. The first is a case where there are contacts with 2 counties, significant contacts with 2 counties. And in those cases, the courts enter into a balancing process. Convenience of witnesses, how many witnesses are here, how material are they, parties, where the parties located, interest of justice, court dockets. That's what this court did in Hugh v. Crockett, which is a leading case, and one that not only got into the balancing, but instructs us what to bring to court when we're going to seek a transfer of venue. And that was followed in this district by Brown and Williamson v. Whittock, which I believe Judge Van Nortwick authored, which expanded upon that and gave us further guidance. And those can be very, very hard cases. But this is not such a case. This is the second type of case. This is the case where there is absolutely no contact whatever with Duval County, the forum, except that 2 of the defendants maintain uninvolved offices in Duval County. 2 of the defendants who are national companies with offices everywhere. Other than that, there's never been a showing or suggestion that there's a single witness in Duval County. The parties aren't from Duval County. Not a document in Duval County. The cause of action obviously arose in Alachua County. Balanced against that, we came forward with a number of affidavits, all of which are summarized in our briefs and attached in our appendix. I won't go back into due to time constraints, and it's not necessary to rehash, but a dozen witnesses testified straight out that trial in Alachua County would be more convenient to them. 6 of them live in Alachua County. Another 6 live in adjoining counties, Marion, or counties that are west or south of Alachua County and further away from Jacksonville. So under those circumstances, the cases that we've cited are unanimous. Yes, we apply an abuse of discretion standard, but in those cases, there's nothing to apply discretion to. And the cases have all summarily reversed for an abuse of discretion, where there's absolutely nothing to hold it in the forum county except an uninvolved corporate office. In other words, this case could have been brought in any county in Florida, and they'd have had the same arguments that they had now. Could have been in Key West if they'd wanted to. Second point, their waiver argument. I don't think it can be seriously argued that venue has been an issue in this case from day one, from the first responsive pleading until the ultimate order was entered and this appeal was taken. There's never been a time that venue wasn't an issue. First case was the Lytle case filed in Duval County. Early motion for venue, to transfer venue, was argued in Lytle, was denied, with the plaintiffs arguing in that case, well, you've shown us some Alachua County witnesses, but you haven't shown us their materiality. That was tough to do at that point because we didn't really know what their issues are. It's not a simple case anymore. It's a construction case. And there are lots of design and construction issues that they might get into. And in fact, those are evolving as the case goes along. So materiality is tough at the outset for a defendant to come in and guess what he's really going to be sued for and who he's going to need to support that. We learned more about that. We kept the venue to the fore, and we learned more about that through discovery and got a pretty good idea what those issues are, and then came back loaded for bear. Well, in the meantime, after the first venue order was entered, the Alexander case is brought, the passenger case, also in Duval. Same timely assertion of venue there. Venue's never heard in the Alexander case. Then came consolidation. Plaintiffs had moved for consolidation. And this is a point that I think is very important here. At the consolidation hearing, on behalf of the defendants, we pointed out to the court that, yes, Your Honor, we defendants think that consolidation may make some very good sense here. But there's one problem. You've ruled against us in the Lytle case. The plaintiffs are saying that we can't raise that issue anymore. But it's a fresh issue in Alexander. If these cases are consolidated, we don't want Alexander to be tainted with Lytle. And the judge invited comments. She said, does anyone want to comment on that? Nobody commented. We heard nothing from the plaintiffs. And then the court said this, okay, well, it makes sense to me to consolidate. So I will consolidate without prejudice to any of your venue issues. I will hear them fresh. And if they are persuasive, perhaps I'll change my mind on Lytle, the first case. So I promise you, a fresh opportunity to persuade me. And she gave us that opportunity. And we failed to persuade her. And that ruling on her part constituted, almost as a matter of law, an abuse of discretion because, hearing the matters afresh, she had before her this overwhelming evidence of Alachua County contacts, and still, even as late as that wasn't the case, there wasn't a single Duval witness, a single Duval party, a single Duval document. Nothing in Duval County except a handful of lawyers, 3 out of 4 of whom were asking to go to Alachua County, and only one wanting to stay, the plaintiffs. So, Your Honor, under these circumstances, I don't see how there could be any waiver. The way they assert a waiver is that their formulation is, well, you had to take an interlocutory appeal. Their words are, you were required to take an interlocutory appeal from that first order. And when you didn't, you foreclosed venue issues in this case forever. And what that necessarily means is that the court, when she even heard us the second time, had to be without jurisdiction to do it. Because otherwise, she heard us afresh. She started with a clean slate. What she did is reviewable on a clean slate, unless she didn't have the jurisdiction to do it in the first place. And that's something they're just bringing up on appeal. They didn't mention that to her at the consolidation hearing or at the hearing on venue, lengthy, protracted hearing. One case that we cited, and I'll close with this, it's the Precision Tune Auto case. Same argument was made in the injunction context, another non-final order, very analogous, with the party arguing that once the temporary injunction was issued, you can't come back outside the appeal time if you don't appeal it and try to get the court to modify it or withdraw it. The court said no in that case. They said we conclude that a trial court's decision as to whether to reconsider is discretionary regardless of whether the arguments or evidence could have been brought to the attention of the court at the hearing on the injunction. And that was so primarily because a trial court always has the authority to modify, change, withdraw interlocutory orders up until the case is disposed of. I see I'm in my rebuttal time, so
we'll reserve the balance of time, Mr. Nolan.
May it please the court, I'm Dennis Desidue from Tampa. I represent the Alexander plaintiffs. Michael Alexander was a passenger in this vehicle. Mr. Pina represents the Lytles. I would like to take 5 minutes for my presentation, and Mr. Pina will take 5 for his. I want to address first the procedural issues that bring us here today, Your Honor. The trial court, Judge Johnson, entered 2 different venue orders. The first one was entered November 12, 2003. The second order, which the defendants seek to appeal, was not entered until July 22, 2004. The pivotal issue here is which one of these venue orders issued by Judge Johnson is the operative order for purposes of determining this case. Was it the November 03 order, which was not appealed, or is it the July order? We submit, Your Honors, that the operative order is the first Lytle order that was entered in 03. The defendant states that there was never a time when there was no venue issue in this case. The fact is that when Judge Johnson entered the first Lytle order, the Florida Rules of Appellate Procedure allow the defendants 30 days from that date within which to take an interlocutory appeal if they wish to challenge the venue order. That time would have expired on December 12, 2003. The defendants did not appeal the Lytle venue order. Then, after that hearing was held and after that order was entered, Alexander filed a complaint and literally followed suit in Duval County based on the fact that venue had been established in Duval County. The first challenge in the Alexander case of venue did not take place until December 22nd, 2003, which is a full 40 days after Judge Johnson entered her first venue order. So we have a 40-day period when there is no venue issue in either Lytle or Alexander. Lytle has not been appealed. Lytle, in effect, becomes fixed in Duval County, where Alexander files his complaint.
Is an order denying a motion for change of venue res judicata, or can it be revisited?
Well, I think it can only be revisited by interlocutory appeal. You know, they say that the court can come back and correct any errors that it has, but in each one of the cases that is cited by the defendants, the defendant took, or the party took, a timely interlocutory appeal to challenge what the court had done in ruling on venue. There is no case that I've been able to read where someone after 30 days has come in and made a challenge to a court's venue order. And what we have here, in effect, Your Honor, is once Lytle is established in Duval County, their efforts to pull themselves up by their bootstraps and later in March of 2004 file another motion in Lytle saying, well, we had this in Alexander and, that issue hasn't been determined and you said you'd give us a chance. Well, the problems that are faced here is if you say that there still exists in the Alexander case a right to challenge venue, that means that Lytle's in Duval County and Alexander is the case that needs to be transferred. But if you consolidate the two, the venue issues in Alexander go away because Judge Carithers, the original judge in Alexander, recognized the impracticality of what the defendants were asking him to do on the venue issue when they filed their Alexander venue motions. He said, I think I'm not inclined to do anything until we see what Judge Johnson does with the motion to consolidate. Because if Alexander is consolidated with Lytle, Lytle's already established in Duval, no timely interlocutory appeal has been taken. Therefore, the venue issues in Alexander have to disappear because the venue is already fixed by the Lytle order.
But what is the impact not only of the court's order consolidating, where she said she will revisit venue, also the stipulation by plaintiff's counsel, if I understand it correctly, that wasn't a problem?
There wasn't a stipulation, Your Honor. The issue that was before Judge Johnson at that time was whether it was right to consolidate these two cases. And she looked at it and said, same defendants, same accident, same witnesses. The only thing that's going to be different is the proof of damages with respect to the different plaintiffs. So it makes sense to consolidate this case. You wouldn't want to have one case in Duval County and one in Alachua County and two separate trials involving the very same accident. So what was at issue before Judge Johnson at that time was consolidation. Now, the defendants made the gratuitous statement, well, if you consolidate, we want to make known that we're not waiving our rights and we want to preserve our right to challenge venue in the Alexander case. Well, and we said nothing at that point because the issue was consolidation. It would be the same as if the defendants had said, Your Honor, I want to make it known that I am Superman, and we say silent on that, and that doesn't make him Superman just because we remain silent.
But the trial court didn't remain silent.
The trial court didn't remain silent, and as a matter of fact, we did not remain silent in the motion on venue, the hearing on venue. Appendix 58 that was contained in the appellant's brief contained 2 pages of transcript. And in those 2 pages of transcript, I'm reading page 26 of that transcript, on the venue hearing, page 11, and this is me speaking, so there was no interlocutory appeal taken, and we have detrimentally relied on that lack of action in filing and pursuing the Alexander case. Now, what I think the defendants are trying to do is they're trying to do a rehearing in the Lytle case based on the fact that we've got an Alexander case where they filed a timely filed motion for change of venue. But I don't think, Your Honor, they can bootstrap their arguments in Lytle with the Alexander case and get, a second or third bite at the apple in Lytle when they passed that opportunity up the first time. And then in her order, Judge Johnson specifically refers to that on page 4 when she says, plaintiffs had the right to rely on venue lying in Duval County based on this court's previous ruling filed on November 12, 2003, denying transfer of venue, and on the fact that there was no interlocutory appeal of that order. So at the time assigned by the court and the parties for hearing the venue motion, we timely raised the issue of the failure to take an interlocutory appeal in the Lytle case. And since Alexander was consolidated with Lytle, it wasn't vice versa. We didn't take the Lytle case and push it back to Alexander. It was Alexander that was being put into an already existing case that was set in Duval County and, which the defendants failed to take an interlocutory appeal on.
Well, counsel, let's assume for a moment that there's been no waiver. You've not really addressed, I don't think, the body of case law of which the Avis versus Broughton is an example. Because as I read the cases, there are legion number of cases arising out of automobile accidents in which there are reversals on a denial of venue transfer. Could you address those? Why isn't this an abuse of discretion?
Well, Mr. Pina was going to specifically address that, but if I can, in his time, but I can make the comment, Your Honor, that in each of those cases, the defendants raised the issue by timely filing an interlocutory appeal within 30 days of the order complained of.
Let's jump over that. That goes back, I think, to the waiver issue. Let's go to the merits of those arguments.
May I defer to Mr. Pina on that, Your Honor? Thank you.
Thank you. May it please the Court again. I'm Ted Pina, and I represent the Lytle family. Our position, quite obviously, is that Judge Johnson did not abuse her discretion in ruling that the defendants did not meet their burden, that this case should be transferred to Alachua County. And I think opposing counsel's comment that this case could be brought anywhere is somewhat alluded to in Judge Johnson's order. There were a lot of places where this case could have been brought, and there was really no venue, no forum in which someone was not going to be inconvenienced. This was an accident on an interstate highway that involved 3 vehicles. No one in any of those vehicles had any connection to Alachua County. There were 3 eyewitnesses to the accident. None of them had any connection to Alachua County. None of the survivors of the decedents have any connection to Alachua County. There are defendants in the case who are scattered throughout the state. Some are in Alachua County, some are in Tampa, some are in other places. And so I think given these facts and given the nature of this accident, again, on an interstate highway involving people traveling from South Florida to Tennessee, and given the fact that the construction allegations in the case involve a temporary detour which was gone the night after this case. This isn't a case where we're alleging that there's a dangerous curve in Alachua County, which is the subject of this lawsuit. Judge Johnson did not abuse her discretion in determining that given those circumstances, some witness or some party is going to be inconvenienced in any of the permissible forums. I think the judge then went one step further and said, even assuming that some of the witnesses are going to be in Alachua County, Florida, and that they're material witnesses, we're talking about an hour and 15-minute drive from Alachua County to Jacksonville. And the judge made a finding, as I think she was entitled to under the Bassett versus Talquin First District case, that the geographic proximity of these two venues, Duval County and Alachua County, is something that she can properly take into consideration. And for someone who's in Alachua County to say that hour and 15-minute drive to come up and testify for the trial is just going to inconvenience me to the point that it should overcome a valid venue selection, I think that was the basis of the judge's decision, and I think that that's why it's not an abuse of discretion. Lastly, I think Judge Johnson in her order expressly stated that the interests of justice require that the action remain in Duval County. Not only did the defendants not show that the interest of justice required the case to be transferred to Alachua County, but she expressly found it should stay in Duval County. Because of the amount of time that had elapsed since the Lytle complaint was filed and the time these venue issues were finally effectively brought up and raised, which was over a year, the fact that another plaintiff had filed in Duval County in reliance on a venue hearing and decision which had already been made, and the fact that for a year the Lytle plaintiffs had been planning litigation on the assumption that this case is going to be in the venue that they chose, and in fact a determination was made that this is the venue where it's going to be. And so for those reasons, we think the judge did not abuse her discretion.
Thank you, Mr. Payne.
Okay, thank you.
Very briefly on the latter point, the judge did say that no matter where we have this trial, some people will be inconvenienced. That's true. That's going to be true in any trial where you have geographic dispersion. What they don't point out is that a lot of people are going to be convenienced, significantly convenienced, because they're in Alachua County or around it. That doesn't apply to Duval. There's nobody in Duval County, not a single witness, nobody except Mr. Pena in Duval County that wants to be there. So, and the convenience in construction cases, let me say this because we do see sometimes that venue is not as important as it used to be, and that's probably true back in the horse and buggy days. But construction cases are a little different because that's hands-on work. To do the construction project, you've got to really be there. You can't do it like some of us do with laptops and things like that. And our evidence is to this effect also. In the case of one of our defendants, they have what is called worksite traffic supervisors. A worksite traffic supervisor, by DOT regulation, has to be within 45 minutes of the job. These people are working a job in Duval County, or else the job shuts down if they're not there. And their testimony is they've got to be within 45 minutes or the job shuts down. So there's some real considerations of convenience in this case. Thank you.
All right, thank you. Thank you all. That completes our